My lords, if I may just mention a matter for listing, my lords. It's a fresh writ appeal. If my lords may permit listing on Wednesday, the 10th.
There is a listing machinery in the High Court.
Please, my lords. My lords, my only request is that the date may be fixed. Hence, I'm mentioning, I'm aware, my lords.
You remove the office objection, it will be listed. immediately.
Please, my lords. The office objections are cleared.
Then wait for 2 days, it will be listed.
Much obliged.
My lord, make one submission. Serial number 10, my lord.
1 second, yes.
My lords, there's a listing request pertaining to the Nandini product, Nandini milk prices which have been increased. There's a PIL which is being submitted, my lords.
We do not know any PIL unless it comes here.
Yes, that is why we want to submit a memo, my lord. Memo for listing, my lord.
No, it will be listed through the usual machinery, yes.
Serial number 10, my lord.
10 years.
Kindly grant me some accommodation, my lord.
When do you want?
Anytime after 15th, my lord.
23rd of July.
Oblige,
My lord.
Serial number 10, what is it about? 10. Oh, like 23rd July.
My lords. My lord. Need to grant dues which are pending the last 5 years, my lord. Petitioner is undergoing back and surface, my lord. Fresh contempt matter, my lord.
Through registry only.
My lord, we've already moved the matter. Matter came up, it didn't reach, my lord.
When it came up.
Last 2 days ago.
There is no ground to list it early.
My lord, petitioner is undergoing surface proceedings, my lord. The dues were pending from the last 5 years.
All matters are being listed within reasonable time. Don't worry. Yes.
Now for listing, my lords, the respondents have filed their contempt proceedings, my lords.
Yes,
Lord,
Mr.
I am the petitioner in the contempt petition and serial number 23, my lord. My senior counsel is not keeping well. Can you give me 1 week's time, my lord?
August, 5th August.
5th.
Yes.
Thank you, my lord.
My lord, serial number 18, my lord. This is a matter related to fixing of fares and fare meters to taxis. An identical matter has been listed on 23/7, my lord. Both the writ petitions will have to be heard together. So therefore, my humble request is this writ petition also may be taken up on 23rd/7.
Pardon, what do you want?
My lord, the serial number 18.
Yes.
An identical matter is ordered to be listed on 23rd July. Both the matters have to be heard
23rd
together.
July. Yes.
23rd
Yes,
July.
ma'am. 23rd July.
My lords, serial number 14, my lordship had directed me to
14.
mention it in the morning to take it up today.
14.
To request, I only request doctrine
So
of pleasure for
what is the
clarification.
What is the
Today.
request?
No, my lords, doctrine of pleasure, my lordship had told reminders in the morning.
Doctrine of pleasure matter.
Please, Rajiv Gandhi, only for
Term
clarification.
is over.
Term is over, my lords. My lordship had directed.
We'll take up, but today there is some.
My lords,
some-
my lords,
some
literally
some
1,500 colleges, no affiliation, no inspection.
Take
my
up.
lords.
We'll try to take up today only, but today there is some paucity of time. So that keep in mind while making requests for urgent hearing. Yes.
My
Yes.
lord, I may be allowed to mention. My lord, serial number 16, my lords. I seek a short adjournment, my lords. Senior is unwell.
Pardon?
My lords, I seek a short adjournment, my lords.
Which one?
Serial number 16, my lords.
16? Yes. When do you want? It will go in July, 30th July.
Obligations.
My lords,
But
kind
that
indulgence, my lord. My lords, this matter pertains to public interest litigation. My lords, there was unauthorized construction is been building up in the
Listed
forest
to-
land, my lord.
It is
Fresh,
listed.
fresh listing, my lord.
It will come
Great.
in usual course.
My lord, it's a unauthorized construction building despite repeated.
Whatever it is, it will come. Wait
Definitely.
for some time. If
Grateful-
it is not
grateful,
listed
madam.
for a long time, you come.
Grateful, my lord.
Lord's serial number 11, my lord.
11.
11. I appear for the state.
I appear for
This
petitioner
matter
in that
pertains
matter.
to-
I appear for the petitioner.
This matter pertains to the 371J reservation, which they're claiming for the medical seats, OCI.
Overseas student.
Please,
Hyderabad,
objections.
Karnataka. Kalyan, Karnataka.
Monday.
Please, my lord. Monday.
Today,
Please,
They have filed their objection. They have given
may
me
we
a
request
copy.
I
that,
filed my objection.
may we request my lords at
today
2
after recess, we may not sit. We are making it very clear. For some other work here, due to
Monday.
some other work.
Monday.
Monday.
Oblige.
oblige.
Same which is covered except that reservation part.
Please, my lord. Please.
Grateful.
Serial number 3.
Please, my lord, an operation mismanagement petition had been filed before the National Company Law Tribunal. When the matter came up, my lord, the other side, my lord, gave an undertaking that they will not, my lord, issue fresh shares without increasing the authorized capital. An undertaking, my lord, was recorded by the court. My lords get that, my lord, at volume 3 ಕೊಡ್ತೀರಾ ಸಾಹೇಬ್ರೆ? Volume 3.
Company side. Huh? 3, 242.
Volume 3 or volume, which one am I saying?
242.
Volume, my lord, page 200 and 1.
217.
ಇಲ್ಲಿ ಪರವಾಗಿಲ್ಲ, ವಾಲ್ಯೂಮ್ 1 ಅಲ್ಲೇ ಕೊಡಿ.
Volume 1 ಇದೆ ಮೇಲೆ.
I am in item 6 and 7. I will wait a minute. No, well, I'm prepared to come after lunch, subject to your lordship's convenience. Oh, your lordship's not sitting. Okay, how long will it take?
Some time it may take about at least about 45 minutes.
No, I'm obliged, my lord, but it'll be a pleasure to listen to my friends Uday and Raghavan. I'll take my chance up to lunch, otherwise I'll request it.
My friend Grace, my lord, that's all that we can say.
Two 4 of them. 11, 32 NCLT rules. NCLT rules ಇದೆ.
No, he's looking at the Companies Act. Yes, my lord. For operation mismanagement. Yes, my lord.
Page number 11, 32.
My lord, it was passed at our instance. What happened was, my lord, initially we asked for, my lord, certain interim orders, because what happened was, my lord, I must bring this to your lordship's notice. There has been. Yes, my lord. Please, my lord. My lord, by the respondent before my lords is a company, my lord, which was floated and promoted, my lord, by a person called Think and Learn, my lord, is the, my lord, it's an Indian company, my lord. Yes, my lord. It was floated by one person, my lord, called Baiju Ravindran. Yes, my lord, Baiju Ravindran. He is, my lord, respondent number 1 before my lords. He is the first respondent before my lords, my lord. His brother is second respondent. They were the promoters. Third respondent, my lord, is his wife. And, my lord, there are other companies, my lord, which he has floated. Subsidiaries, all that. Huge monies were, my lord, collected. My lord, 969 only I'll take, my lord. Whatever your lordships, my lord, are comfortable with. 969 is what you...
Yes.
Yes, my lord. 972, my lord. 969 kotilva. 969, my lord, if your lordships can, my lord, have it, my lord, I'll just point out, my lord. There has been, my lord, misappropriation, mismanagement. There are at least 10, my lord, winding up petitions. That's now, my lord, winding up has now become what is known as a corporate insolvency, my lord, resolution process. 10 of them, my lord, in the National Company Law Tribunal, Bangalore. There are, my lord, suits filed. 10,000 crores, my lord, are due, my lord, in respect of one company. The company has filed, my lord, winding up. It has filed, my lord, petition, my lord, suit before the commercial court. There are proceedings, my lord, before the Singapore, my lord, arbitration center, where, my lord, interim orders have been passed because 2,000 crores is due to that company. There are, my lord, proceedings in, my lord, the US, Delaware court. Person has, my lord, just taken away, my lord, 5,300 crores from his subsidiary, just vanished, my lord. And he says, he has the temerity to say, no lender will get this. He was, my lord, summoned. He was asked, my lord, he went into the witness box. He says, I don't know where it is. But who sent it? Think and Learn, of which, you know, he is the director, managing director, the whole and soul. It is in this background, my lord, that 5,300 crores has just vanished. In this background, my lord, operation mismanagement petition was filed by us because we are shareholders. There have been, my lord, siphoning out funds, everything, my lord, every kind of a mismanagement has happened. This gentleman, ED proceedings have started. There is, my lord, lookout notice for him. He goes and sits in Dubai. He is not available at all. It is in this background, my lord, where, please, my lord, I am an investor. I have invested into this company called Think and Learn. Yes, my lord, shareholder. I am a foreigner, foreign shareholder. I have, my lord, we are a bunch of them. We have filed, my lord, operation mismanagement petition under. Yes. When, my lord, the matter came up before the Company Law Tribunal on the first date of hearing, they gave an undertaking because, my lord, they came up with what is known as a rights issue. Contrary to the company law proceedings, my lord, company law, they were trying to give, my lord, rights issue to, my lord, preference shareholders because it can only be to equity shareholders. At any rate, my lord, we said, my lord, there are a whole lot of mismanagement, misappropriation, siphoning out funds. Therefore, my lord, we filed the petition. Then, my lord, when the matter came up before the court, please come to, my lord, page 201. An undertaking was given by them. Yes, my lord. My lord, first rights, what happened was, first right was, my lord, they, my lord, they said, we will not issue the shares. Rights, my lord, was, my lord, up to, my lord, a particular period, collected some money, but we will not issue the shares. Please come to, my lord, the order at, my lord, page 205, paragraph 10. Sorry, my lord, my apologies. Yes, I entirely agree with your lordships. But then, my lord, no, they are probably little tense. They must relax. That's what I keep telling all the juniors. All lawyers must be, my lord, relaxed. That's your lordship's grace and my lord. Absolutely. Page 205, my lord, the undertaking. Please look at that undertaking. Paragraph 10 at page 205. My lords, get at the bottom. On the other hand, my lord, we said we press for certain interim orders, including, my lord, this rights issue be stopped. First rights issue. On the other hand, learned senior counsel for the respondents 2 to 4 again gave an undertaking that they will not allot any shares. There will not be any allotment of shares without increasing the authorized share capital as per the provisions of the Companies Act. And further, the amounts and funds collected in respect of the rights issue will be kept in a separate bank account, will not be drawn for any purpose of the company. On the basis of the undertaking, learned senior counsel appearing for respondent 1, petitioner 1, stated that the undertaking given by the learned senior counsel was acceptable to him with regard to his pleadings in the matter. Considering this, my lord, the NCLT at para 11 says, yes, this is the undertaking. Contrary to this, my lord, they, my lord, go ahead and allot shares. Please come to, my lord, page. They given, my lord, an affidavit is filed before the court. My lord, after this order, there is one more order dated, my lord, 4-4. The NCLT affirms that order. My lord, this order is dated 27-2. My lord, no, my lord. This is 27-2, my lord. Page 201, my lords, get that.
You are referring to other appeal. Their lordships have. You are referring to the 709 WA.
What is this, man? There, my lord, they reiterate and say, my lord, that they will scrupulously, my lord, adhere to, my lord, the order that was undertaking that was given. Which part? Madam, 4-4, there is a reiteration. Please come to, my lord, paragraph 3 at page 209. My lord, can I be permitted to read, my lord, para 2 onwards so that there's continuity, my lord? Page 208. Matter has been argued at length. Learned senior counsel for the petitioner stated that they have filed additional affidavit wide diary number 2123 dated 3/4/2024 regarding inspection of statutory records of the respondent number 1 company. Second additional affidavit dated in a wide diary number 2128 dated 4/4/2024 regarding violation of the undertaking recorded in the order dated 27/2/2024. Same was taken on record. Learned senior counsel for the petitioner argued that respondent number 1 had allotted shares on 2/3/2024 without increasing the authorized share capital and has breached the undertaking given by the learned senior counsel for respondents 2 to 4 as recorded in the order dated 27/2/2024 of this tribunal. On the other hand, learned senior counsel for respondents 1 to 4 stated that they have not violated any of the undertaking given before this tribunal, seeks time to file response to the above 2 additional affidavits filed by the petitioners. Please come to para 5, my lord, now. Para 5. Considering the aforesaid submissions, they wanted to, my lord, file a response to our affidavit. Considering the aforesaid submissions, we reiterate direction given wide order dated 27/2 and in CA 38 of 2024 dated 28/3/2024 have to be followed scrupulously. So, my lord, court NCLT reiterated its earlier order, which, my lord, recorded the undertaking. Where is that affidavit? Affidavit. Which para? Volume. Court master. Volume 5. In volume 5, my lord, they filed an affidavit as they undertook, my lord, the court before the NCLT. 969 ali.
Page number.
Page number. My lord, they say, we have issued the shares on, my lord, a particular date without increase in the authorized capital. Thereafter, my lord, one more interim order was passed. Correct, my lord. That was impugned before the learned single judge, and the learned single judge has allowed it, my lord, and then, my lord, remanded the matter. One 1309. One minute. 1 minute, sit down. I know that. Tribunal again, but then, my lord, what happens is, in the meanwhile, my lord, there is no protection. So, my lord, they'll re-allot the shares and dilute, my lord, everything. Therefore, at least, my lord, the learned single judge should have said, all right, maintain status quo, let the tribunal. Paragraph 10, my lord. Paragraph 10. Page, my lord, 200 and...
That's a appeal.
1 minute.
It's page 7.
1 minute. 200 and, my lord, 5. ಇಲ್ಲ ಡಿಸ್ಟರ್ಬ್ ಏನಾಗೋದಿಲ್ಲ. I don't know, they were when I said actual undertaking, my lord, is this only. They have recorded it. That's all, my lord. When, my lord, I give an undertaking, my lord, senior counsel, your lordship will not say file a memo, my lord. Please. Yes, my lord. All that I am saying is, my lord, let there be, my lord, the status quo as on today. Continue, my lord, whatever.
My lord, kindly look at the order that has been passed. All this, my lord, is totally irrelevant. In fact, in the order that has been impugned before the learned single judge, the Company Law Tribunal says, I will not consider all this. Kindly look at the order that has been impugned before the learned single judge. My lord, that's important for you. Kindly see which order was impugned. All that my learned friend saying, my lord, is, if I may say so with due respect, straight irrelevant for the purpose of the present case. Please look at the impugned order, my lord. If your lordship will kindly look at the order which has been impugned, which is, my lord, the order dated 12th of June, which your lordship will find at page 45. My lord, if your lordship, I'm sorry, my lord. Oh, I'm sorry, my lord.
CH-127.
Kindly turn to page 127, Lord, I'm sorry. Please be kind enough to turn to page 127. Yes, my lord, kindly see, all that the learned single judge says is, this order is bereft of any reasons. This is the only ground on which the learned single judge says, this is a fit case for me to entertain a writ petition, because I'll read all that I need to do is to read the order. And your lordship will kindly see there's no reasons. No reasons at all. Please see the order. Nothing. No, it has not. Kindly, I'll read the order, madam. I'll read the order. Please see what the... No, there is... This is... No, madam, I am saying there is absolutely no reasons. It is not a case of adequate reasons. Zero reasons. Not even one line. There is not even one line. Madam, there is not even one line. I am saying so without fear of contradiction, there is not even one line. But that's the aspect on which the learned single judge is, that was the bone of contention with the learned single judge. We contended that this order is a order bereft of any reasons, not sufficient reasons. Yes, that's what the learned single judge has done. But actually, I must tell you, lordships, my lord, they did not want it. Before the learned single judge, they didn't want it.
Sit down.
My lord, undertaking, there's no violation at all. I will be able to satisfy your lordships on that. Status quo as on today, my lord, I think we are okay, my lord.
Please, my lord. I think
That's
that
all.
solves all the
That's
problems.
all, that's all, my lord. I don't think we need to take my learned friend, Mr. Chidambaram, for too long, my lord.
Status quo, my lord, must be as on the date.
No,
my
no,
lord.
no, as on
Yes.
the, as on today, we will maintain status quo, because they did not have any
Well-
protection.
12/6, my lord, please look at it.
As on the date on which,
Can I? 12/6.
my lord,
As on today, as on today.
as on today, we will maintain status quo.
I'll tell you. My lord,
And let
can I-
let the company law board decide the matter. Let us has only done it 2 weeks.
my lord,
He has already done
12/6,
it.
my lord, I'll tell you, lord, 12/6, my lord, the order was passed by the.
Exactly.
How can it be? Status quo isn't good. No
Yes.
further,
Correct.
My lord, there was no interim order in their favor before the learned single judge. Please look at it. Suddenly, my lord, day before yesterday, my lord, he. Can I submit this? At least, my lord, on the date, my lord, when the learned single judge passed the order, status quo as
No,
on
no.
that date, my lord. Please look at it. On the date when he passed the order. They want to issue now. And my lord, from that day, my lord, what has happened? I'll tell you, lordship. I don't know, my lord. They'll have to tell us.
But I think some,
we don't know. We don't know. We don't
my lord,
know.
I must say, my lord, I don't have full instructions on that. As on today, my lord, I will communicate to the
As on the date
parties
when
that
he
they
passed
should
the-
maintain status quo.
And
As on today, don't alter. Yes, my lord. Please pass that order.
My lord,
No
please,
difficulty.
please
Let
look-
it-
please look at this. Brazen undertaking violated.
No, that is not correct, my lord. I mean, if he wants to argue on that, I will argue also on that.
My lord, during the interim, they have, my lord, allotted, my lord, certain shares. Therefore, my lord, that also
That
has been
can-
frozen.
that
Please
can't
look
be.
at it.
Whatever
Please
has
look at-
happened
Learned
without,
single judge, my lord, passed an order, my lord, day before yesterday. As on that, till that, my lord, there was no stay order. Please look at it.
without,
Learned single judge did not grant an order of stay. Learned single judge, my lord, sets it aside, my lord. Yes. Correct.
but
That's all. As on the date of, my lord, the order passed by the learned single judge.
Absolutely.
I'm sorry, man.
yes, that's all. Yes. No further transaction. Correct, my lord. Absolutely, my lord. In fact, whatever has happened, anytime will be subject always to the result
I-
of the final
can I-
hearing.
can I-
No difficulty.
Can I, my lord, can I seek one?
They don't-
Can I seek one caveat, my lord? They can't plead, my lord, equity on the basis of, my lord, whatever they have done from the date. Yes.
That's all. That's all. It- in Namge, I would have put it also. All that the learned single judge has done is to set aside the order, remand it, saying, give reasons and pass an order. In fact, the learned single judge holds, my lord, is iconic, bereft of reasons, non-application of mind, everything.
Lord, absolutely, absolutely, my lord. Correct.
Yeah, please pass on. No difficulty, my lord. In fact, I am clear in my mind that we have not violated even a comma full stop of
course.
undertaking.
My learned
No
friend, my lord,
difficulty.
optimism
My
and
lord, my
majesty,
learned
yes.
friend can say it up umpteen times. In fact, the company law board says, I will not go into it. My lord, yesterday it was there.
What was the?
It was there yesterday. And in fact, my lord, I must also say, they wanted an extension of time. In fact, my lord, the company law. My lord, yesterday, the learned company law tribunal, my lord, it is my duty as officer of the court to point out to your lordships, and we told the NCLT that we will do it. They expressed some difficulty because of the work pressure that they may not be able to dispose it of in 2 weeks. Therefore, my lord, in fact, the NCLT requested us to bring it to your lordship's notice.
Wait.
Please, ma'am.
My lord,
Only
your
thing is,
lordship,
I
there's also
believe,
another thing I want to
second
point out.
and third, after the learned single judge order, they allotted shares, I believe. That's my.
That we will see, my lord. All that cannot be orally, my lord. I will point out if they file an affidavit, what has been done.
Now the cat is out of the bag.
Huh?
Now,
What?
my lord, he said, I have no instruction. Now he says,
I will find,
Please look at
violate,
it.
I will find out.
Undertaking
as
given
what-
violated to the
No,
impunity.
there is no violation when undertaken. My learned friend can repeat it ad nauseum. I will also say ad nauseum, it's not done. It's going to take us nowhere. No, yes, my lord. Yes.
Only thing is, my lord,
The single judge has also said that.
the,
He has said everything. I know. But
only thing is, my lord, they shouldn't, my lord,
undertaking, my lord, there
They
is
should
no
not be
violation of
equities.
any undertaking. That much, my lord, I will be able to satisfy your lordships fully. No, that's why, my lord, no difficulty. As on today, my lord, status quo.
only thing is, my
No
lord,
difficulty, my lord.
whatever has happened during those 2 dates, my lord, will be subject to the
My
result.
lord, my lord, it can't be all in the air, my lord.
My lord, on the date, my lord, when the learned single judge passed the order, 2nd of July, till now, whatever has happened will be, my lord, subject to your lordships, my lord, subject to the NCLT's, please, my lord. And there is one more aspect, my lord.
My lord, in fact, I am saying, my lord, everything that happens during the pendency of a company petition is always subject to the final order. Where is the question, my lord? I mean, it can't be that all these observations is taken for your lordships and shown to the NCLT saying, look at what the Honorable Chief Justice sitting in the division bench has said. And all this is becomes a problematic. And tomorrow, it is published in the newspaper as headlines. Everything that orally happens also is published. Insofar this case is concerned. In fact, my lord, an observation was made by the NCLT member. It was published as headlines in the newspaper yesterday. No, my lord, it should not be. I am only saying, my lord, no, my lord. What happens is, I understand. I agree, my lord. I mean, courts are insulated.
Here is that order.
My lord, your lordships will say 31st of July, my lord. And status quo as on today.
My lord,
Without any
one more,
all, yes, my lord.
one
Yes,
more
ultimate.
submission, my lord, if I can request your lords, please look at page 48. There were some disclosures they had to give.
My lord, no, my lord. All that if you want to argue, my lord, I am ready to argue that also. There is no difficulty. All right.
Page 48. Please look at para 10, my lord, the bold headlines, bold letters. 48. My lord sees at the, my lord, para 10, bold. Accordingly, respondents are directed to file complete details. The allotments made. What is wrong with it, my lord? 130, my lord. I'm sorry. 130. Paragraph 10.
10. It will be para 10.
We have two papers. Accordingly, respondents are directed to file the complete details of the allotment made on 2/3/2024. Without that, my lord, how will the NCLT decide, my lord, the matter? Please look at it.
Exactly.
No, I'm not saying, my lord, they have not complied. This, my lord, they'll have to disclose, my lord.
There is
This
no
need not be
prayer.
stopped.
There was not even a prayer in the application. Exactly. Exactly.
That's all right.
No,
That they have said.
All kinds of orders were passed, which is not subject matter of the application, no prayer, and no reasons given as to why this is being done.
At least, my lord. Oh, nothing, my lord. I don't know. Nothing, my lord. Disclosure, my lord. Every shareholder has a right. When we went there, they gave me, my lord,
In fact,
papers.
there have been, there was another proceeding, my lord, where all this were debated and no directions were issued. I will show to your lordship that also. Suddenly this comes up from nowhere. Exactly. Very well. Grateful.
Anyway, grateful to your lordship, my lord.
I must say, my lord, not only have the councils, my lord, been very efficient in filing an appeal, I compliment them. Even the copying machine has done a great job, my lord. Copying machine.
My lord, more efficiencies, my lord, of the court, my lord. Your lordships have been able to, my lord, resolve the controversy, my lord, in just, my lord, 10 minutes. Please, my lord.
Notwithstanding, my lord, it's been submission for half an hour. Grateful, my lord.
Lord, my lord, may I just make one summation in the connected appeal, which is appeal number 972 of 2024. Lord, I'll be entering appearance for the appellant and I adopt all the arguments which Mr. Hola has already addressed. My lord.
There is a
I
second.
was
my lord,
unable
I
to
believe.
hear, my lord.
I appear for the
That's all,
response.
same thing, my lord.
They are over.
In-
One is a
So-
appeal that has been filed, my lord, in a writ petition filed by the promoters. There is another writ petition that was filed by the company.
That's correct.
Two writ petitions disposed of by a
So-
common order.
That's
why
right.
Two writ appeals have been filed.
That's right. That's right. So Mr. Hola appeared in appeal and writ appeal 969, my lord. I'll be appearing in writ appeal number 972, which is listed at item number 4.
It is the same order.
Yes.
Yes, yes, absolutely.
We'll record your appeal.
I'm so grateful, my lord. I'm so grateful.
Please.
Interesting.
Very grateful.
Lord, one very heavy weight, my lord, is off our chest, my lord.
I'll help you, sir.
No, no, thank you.
Thank you.
This one, no, 7693.
Yes, number one. To Mahesh, yes.
Please, your lordships, I beg to appear on behalf of the petitioner. Your lordships, this is a contempt petition of the order dated 20th February 2020. If your lordships would have that order, that's at page 47. Your lordships, I hope I am audible.
So page 50 is the directions.
Yes, the directions are threefold. Prayer A, B, and C are allowed. If your lordship,
Which page? 54.
The order is at page 47. It starts.
No, the directions which are brought under contempt, where are they?
Your lordships have page 50, 50.
55.
50.
50, yeah.
It says prayers A, B, and C are allowed.
Yes, where are
If your lordships will see the prayer, that's at the first page, page 47, the first paragraph. Attach 2 crore 10 lakh 50,000 shares of BPL Medical Technologies Private Limited held by JDR and prohibit JDR from transferring shares or receiving dividends. Now they have received dividends of 18 crores.
Our learned counsel, so and so, notice returnable on 31st July.
I'm grateful, your lordships.
So number two.
It's appear for the appellants.
Madam, you come on 9th.
My lords, maybe on third week, my lords. Maybe any date on third week, my lords. Second
Pardon?
week, maybe any date on third week, my lords.
Any date of?
On third week of this month, my lords.
No.
My lords,
Every time,
because my mother is not well, I am an outstation next week, my lord. That is the reason.
24 lakhs is deposited, my lord.
Wait for some time. We are aware. The mother of the council is not well. Then third week.
Any date.
And 18th.
Grateful.
18th. Come on, 18th.
Grateful.
Severe financial crisis, my lord.
18th, yes.
I have to take treatment, my lord.
We'll take up.
I've got a hemolysis of blood, my lord. I have to be transfused with blood, my lord.
It is already,
8 bottles of.
it is already in the process of hearing, madam. We'll take it.
Lord, at
4-5 dispose. Number
2:30 I have to come.
You come at 2:30.
3-4 dispose. Number 5. Mohammed Tahir for withdrawal of writ appeal.
For appellant, my lord. Filed memo for withdrawal, my lord. may be permitted to withdraw the same.
Withdrawal.
Yes, madam.
Learned advocate, so and so invites attention of the court to the memo of withdrawal dated 21/2/24. Stating that his instructions from the appellant to withdraw the appeal. Permission is granted, the appeal is disposed of as withdrawn.
This.
The writ appeal matters, seal number 6, Mr. Rajeshwar P.
May it please your lordships. Lords, appeal against the order of the learned single judge who has practically relied upon a Kerala High Court learned single judge and adopted the judgment and come to the same conclusion. If your lordships will kindly have writ appeal 943, volume 1, the order appealed against starts at page 26. Now kindly come to, I'll just show, my lord, without reading it, that he has virtually reproduced the Kerala High Court judgment and has adopted it. Kindly come to page 30. We are concerned with import of black pepper at what is called an minimum import price, MIP. The MIP is 500 rupees per kilograms. The policy, my lord, is, as your lordships know, there is policy of 4 kinds: free, prohibited, restricted, and exclusive trading through a state agency. In the case of black pepper, anything above 500 rupees is free. Anything below 500 rupees is prohibited. That is the law, the policy. Now kindly come to page 30, 5th line. We are concerned with a notification dated 25/7/2018. This was challenged in the High Court of Kerala in WP so and so. Then, my lord, kindly see, after setting out the notification, kindly come to page 40, middle of the page. This notification comes to be stayed by the High Court of Kerala in the aforesaid writ petitions. The writ petitions, as on today, are dismissed. Page 40. I'm just showing that he has virtually adopted and accepted, which of course he's entitled to do, the Kerala High Court judgment. After referring to the writ petition at page 40, middle of the page, this notification mentions it is in supersession of the earlier notification. This notification comes to be stayed by the High Court of Kerala. The writ petitions are on today dismissed. Now kindly come to page 42, middle of the page, High Court of Kerala, while dismissing the writ petitions, etc. It's all extracted, and I'll read that portion, extracted up to page 51. And then at 53, after the quotation, in the light of the judgments noticed above, the law is heavily goaded against the petitioner. Just sit down, yeah. That's okay. The law has got it. The entire reliance made by the petitioners on the interim order granted by the High Court of Kerala. The High Court of Kerala has dismissed the writ petition. Therefore, the very fact that the sheet anchor of the petitioner has tumbled down, the present petitions do not deserve any further indulgence. The challenge to the notification is the same as was done before the High Court of Kerala. The High Court of Kerala, having rejected the challenge by the aforesaid order, to which I am in complete agreement, there is no warrant of interference. So virtually, my lord, here, the learned judges adopted the Kerala High Court judgment. The Kerala High Court judgment is an appeal. The appeal has been admitted. The appeal has been admitted by order dated Abhipan? I'm not able to, no,
Sorry, appeal is before Supreme Court or intra court?
no. Appeal is before the Kerala Division Bench.
Division.
Supreme Court matter, which is referred to, arose out of apples, the same issue. MIP in the case of apples, the Supreme Court, there are a number of courts which have granted stay of the notification. The matter went to the Supreme Court where they modified the order by saying you need not pay the cash, you can give a bond. That is the order passed by the Supreme Court in the case of apples. But the issue is the same. Whether an MIP can be fixed by the DGFT. Well, your lordship knows there is the Government of India, which is the Ministry of Commerce in this case. Under that, there is a Director General of Foreign Trade. The impugn notification ex facie shows it is issued by the DGFT. Just kindly see the notification. Ex facie shows it is issued by the DGFT. Page 8. One of you come here. No, you please sit there. 84 of volume 1. Why don't you come here so that? In exercise of powers conferred by Section 3 of the Foreign Trade Development and Regulation Act, read with paragraph 1.02 and 2.01 of the Foreign Trade Policy, as amended from time to time, the central government hereby amends the policy condition of pepper classified under Chapter 9. Now kindly see, this is issued by the Ministry of Commerce, Department of Commerce, DGFT, and who has signed it, my lord, at page 86 is Alok Vardhan Chaturvedi, Director General of Foreign Trade. This is the ex facie, this is issued by the DGFT. This is the ground we raised, saying that the DGFT has no power. Under Section 3 of the Act, which I will show presently, only the central government can make the notification, and the DGFT may authenticate it. That's a different matter. Now, Kerala High Court found that, I'll show the portion, Kerala High Court found on the basis of a counter affidavit that the matter was issued after, quote, discussion with the minister. That is the word in the counter affidavit. Kerala High Court accepted that contention and said, if a notification is issued after discussion with the minister, it is issued by the government. The learned single judge of your lordship's court has also accepted the same issue. Please remember that the ground was that the government has not issued it. Answer is, government has issued it, and it is supported by the contention in the counter affidavit reply that it was issued after discussion with the minister. Now, for the time being, I am questioning the discussion with the minister. Discussion with the minister is not issuing by the government. The minister or the secretary, who are constitutionally one, your lordships have held so, must sign on the file that this commodity deserves a minimum import price. And secondly, the minimum import price shall be 500 rupees per kg. That file was never produced. We argued before the learned single judge on a demurrer, assuming that the government has issued it. Show us the file where the minister has signed it or the secretary has signed it, or the 500 rupees MIP has been fixed. Alternative, the second argument is, assuming it is issued by the government, It should be placed in Parliament, which has the power to modify under section 19(3). And there is no averment that was placed before Parliament.
But this, the DGFT is not a competent authority.
DGFT, the learned judges of Kerala and this court have held, is only an authentication authority. That's a finding. It is discussion with the minister. The order is issued and authenticated by the DGFT. The finding is, who has issued is, let us assume so, Miller. Discussion amounts to issue with the government, which I seriously question. Discussion with the minister is not issuing with the government.
What could be the right process to issue the notification?
The right process is the minister or the secretary should sign the file, showing 500 rupees.
Who should sign?
The file is not produced. The file was not produced. We said the file must be produced. If the minister has signed it or the secretary has signed it, your lordships have held long ago.
But this
Minister and secretary are constitutionally one.
notification is a legislative exercise.
Notification is legislative exercise.
Therefore, there is a presumption of validity.
We'll assume it's presumed. Then kindly see 19(3), and this is covered by a judgment of the Supreme Court. It shall be placed before both houses of Parliament, which has the power to cancel it or modify it.
So
The
this is not-
legislative, no, we have searched, it's not been placed. And no, nor is there an averment it was placed.
Again, it would depend upon the language of that section.
No, please see
What-
the language. The
in what
language is
way-
very clear.
In what way,
mandatory.
in what way ratification is contemplated?
Please see.
Mere
please see.
tabling, ratifying,
Please see
approving.
the language. Lord, I'm on very strong ground. Please see the language of 19(3).
Section 18.
Where is the portion? Every rule, 19 subsection 3, every rule
19.
and every order made by the central government. On a demurrer, I'll accept it, 19 subsection 3.
Yeah.
We'll accept for the time being central government. I'm not conceding it. Made by the central government under this act shall be laid as soon as may be after it is made before each house of parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more successive sessions. And if before the expiry of the session, immediately following the session or the successive sessions aforesaid, both houses agree in making any modification in the rule or the order, or both houses agree that the rule or the order should not be made, the rule or the order, as the case may be, shall have thereafter have effect only in such a modified form or be of no effect, as the case may be. So the parliament can cancel the order. People can represent to MPs saying this order is detrimental to trade, detrimental to the commercial interests of so many people. Please cancel the order. They can cancel it. This was never placed. And this is covered, my lord, by the judgments which say that a notification which requires to be placed and gives the power to Parliament to modify it or cancel it is mandatory. Is mandatory. That is 2013, volume 8, SCC 271. At paragraph 66 to 67.
271.
2013, volume 8, SCC 271. At paragraphs 66 to 67. My lord, the Chief Justice is right. In some cases, it's only being laid.
Tabling.
Then they say it's directory. The same judgment says it's directory. I'm raising 2 grounds. I'm saying the file, the learned judge should have satisfied himself by seeing the file, whether the minister or secretary have signed it. And have they fixed the 500? Milord, it is not
Now
one thing to...
You're also questioning the very power to fix the minimum price.
No, because he may agree to a minimum price.
Who?
The minister. All right. In a discussion, he says, all right, we agree there should be a minimum price.
No, but for that aspect of minister discussing this, so notification is legal, could have been issued or not?
It
Fixing
could have
minimum,
been issued
minimum
by the
import.
government placing it under 19.3, it could have been issued. I'm not questioning the power of the government to issue it. Under section 3 of the Act, the power of the government to issue is there. Kindly see section 3, madam.
No, power of not issuance of notifications, power to fix the minimum import price.
No, but the notification can impose conditions. One condition can be an MIP. I'm not questioning that.
That's all.
I'm not questioning that.
But then
I'm only saying, did the government issue it? One. If the government has issued it, did you not? You didn't place it before 19.3. Milord, both in Kerala and this honorable court, we had a stay of the notification right from day one. In Kerala, after the learned single judge dismissed the writ petition, which is the same paragraphs have been adopted in this judgment, the writ appeal has been admitted, notice has been issued. In Karnataka also, there was a stay granted. The stay inured to us until the judgment was delivered. In fact, my lord, I'll tell you, lordship, the dates. 8/2/22, stay was granted by a learned single judge. Where is this? Page 41. What is this? Page 41. Judgment. Where? 41 of what? Yes, ma'am. Now, my only request is, I've served the other side in advance.
I appear for response. Take instructions because day before yesterday only corrected copy was served. I request the department to issue some instructions, maybe taken up next week minutes. I have requested the instruction from the department. I sent the copy of the appeal memorandum to them. I may request short accommodation. Maybe a week's time may be granted.
Judgment of which? Single judge. My lord, in all these cases, because the commodity is perishable, both in the Supreme Court, apples, and in several orders of, even in Kerala, and even the learned single judge of this court have held. Kindly see, my lord, the impugned judgment, the last paragraph. Impugned judgment, last paragraph, volume 1, it's at page 54. Last paragraph, an application is filed before the court to de-stuff the black pepper, which is stuffed in the cargo. That is, Miller, remove it from the container. The score that black pepper is a perishable commodity and would incur huge losses. While incurring of huge loss cannot be considered in the light of the order, it would be open to the petitioner to get the black pepper de-stuffed from the cargo in accordance with law. If the petitioner would submit a representation for de-stuffing of black pepper lying in the cargo, the respondent shall consider the same and pass necessary orders in accordance with law. In the light of the fact that if black pepper is permitted to be perished, it neither benefits the petitioner nor the authorities. What this, even the learned single judge who dismissed my writ petition has said de-stuffing should be done. I have applied to them for de-stuffing. They should de-stuff it. That need not await any further orders of the court because they are not an appeal. Only I am an appeal.
Yes. But as far as the differential duty is concerned, total amount, what has been demanded, quantified, that request to be secured, my lords. That's the one, that amount request to be secured.
My lord, after de-stuffing, what happens to the... No, he said yesterday one container has been de-stuffed, 3 containers.
And as far as Your Worships.
What are you saying?
I'm saying that as far as the authority issuing the notification is concerned, Honorable Supreme Court has considered the very same issue in page number 299, judgment produced by the appellants regarding
Volume 3.
page number 209 of appeal number 943.
I'm looking for the Kerala High Court judgment. You are saying volume.
So only permission is given to remove the goods from the cargo, paper.
But to remove that, the assessment and the duty has to be paid. That is the valuation adjudicating authority.
All,
That's what they're.
all subsequent measures the authority may take will be subject to outcome.
No, my lord, I have no difficulty. All I'm pointing out is, has volume 3 been given to my lords? Now kindly have volume 3. Is a page. Just kindly have volume 3. The Kerala High Court judgment starts at page 20, Justice V.G. Arun. And kindly come to page 41. What are you showing? What are you? Can see them. Third line. Or start from the first line, my lords. Did not of the force of law, as they had not been laid before the Houses of Parliament, as required under section 3(6) of the Essential Commodities Act. The respondents, this is an atlas, section 19(3). The respondents conceded that the notification had not been placed before both Houses of Parliament, but contended that the provisions of subsection 3. This is well, whether this.
How come essential commodities?
I beg pardon?
Essential commodities.
93 is here. He should be able to understand. Well, this is quoting from Atlas Cycle. I am not disputing that. That's why I said they do not contend in answer to me that it was placed and this is the notification placed before. Because it will appear in the parliamentary bulletin, Miller. What are the notifications placed before each house will appear in the daily parliamentary bulletin. They could have easily produced the file to show that the government took the decision. And they could have easily placed the notification saying placed before parliament. I specifically contended that the minister did not approve this decision of MIP and 500. And in any event, it was not placed before Parliament. So they have to take a stand on those two issues, Miller. If your lordships calls it after a few days, they'll have to still take a stand on those issues. They should either produce the file and the parliamentary bulletin or concede that it was placed or not placed. Because otherwise, further hearing will become futile, Miller.
Let us see. Right now. Centripetal to the controversy is the notification dated 25th July 2018.
Placed at concession.
Hearing number 21/2015-2020. Issued by the Government of India, Ministry of Commerce and Industry, Department of Commerce, which is issued in exercise of powers under section 3 of the Foreign Trade Development and Regulation Act 1992. Read with paragraph 1.02 and 2.01 of the Foreign Trade Policy 2015-2020, 2015-2020, as amended from time to time. Full stop. The notification deals with fixation of minimum import price of black pepper. The challenge in the writ petition?
Notification is at page 84, Miller, volume 1.
Yes. Into bracket figuring at, copy figuring at page 84, next one. The challenge in the writ petition was to the validity of the said notification dated 25/7/18.
Conceded it was not.
Learned single judge dealing with the challenge in the petition, dismiss the same
Conceded in this case.
by extensively relying on decision of Kerala High Court in Messrs. MRJ Trading versus Union of India, which was writ petition and duplicate C 19351 of 2021, decided on 25/8/23. In light of the above decision and what is held therein, learned single judge, while negativing the challenge to the validity of the notification held, observed, that the law was heavily guarded against the petitioner and that the judgment of the Kerala High Court had rejected the challenge to the very notification. Paragraph, learned senior advocate Mr. P. Chidambaram, assisted by learned advocates Mr. So and so, so and so, submitted that although one of the High Court has dismissed the petition challenging notification, there are certain material aspects arise which go to the root of the challenge and that they are required to be considered. It was firstly submitted that the issuance of notification was preceded by discussion with the Honorable Minister concerned, and that only basis was the discussion with the Honorable Minister. It was therefore submitted that it could not be equated. The process of issuance of notification therefore could not be equated with the government issuing the notification. Full stop. While not calling in question, while not calling in question the power to issue the notification, it was submitted that when the exercise needed in law was not undertaken before issuance of notification, it becomes liable to be set aside. It was next submitted that it is an undisputed, it is a fact not capable of being disputed, that the notification was not tabled before the houses of the Parliament, and in view of full stop, and it was further submitted that in view of subsection 3 of section 19 of the Foreign Trade in Duplicate Development and Regulation, over 1992, tabling of the notification and clearance thereof by the Houses of Parliament, either as received or with modification as may be considered, would not bring into effect the notification. It was submitted that that tabling and approval by the Houses the condition precedent. Is a condition precedent.
I'm not able to hear a lot.
Tabling before the Parliament is condition precedent.
Yes, the legislative process is not complete unless it is placed before the.
Precedent inasmuch as without compliance of subsection 3 of section
Because
19,
it's an inchoate proceeding. You have to complete it.
correct. The legislative process could not be said to be complete and it remains inchoate.
That is my submission.
Notice returnable on When?
My lord, I have just one submission, I'm sorry. I have a prayer for interim stay, but your lordships may wish
They
to
will not
hear
be
it.
able to.
I agree, I agree. Therefore, these are pure two legal questions. Did the minister or secretary sign it? Was it placed? It will take 5 minutes for your lordships to look at the two legal questions because the authority is very clear. If your lordships are not able to dispose it off finally on the next date on these two issues, if he satisfies your lordship, I'm out of court. That the minister signed it and it was placed before Parliament, I have no further ground.
It has to be threshed.
Otherwise, then your lordship will consider the interim order next time. That's all I'm requesting.
Always, court can always consider at any point of.
No, because if the writ appeal lies for a few years or a few months, then it'll be, no purpose will be served. Therefore, I am an importer and exporter. I need to import and trade. If the notification is valid on both grounds, then I'm out of court. If the notification is invalid on either ground, then I'm entitled to a stay, my lord. I'm entitled to the writ appeal allowed, but if your lordships are not able to dispose of the writ appeal, then I should be allowed.
Is right, but interim stay we will not be able to grant at any stage until finally decided. For
No,
two
but-
reasons. One, it is legislative exercise. Two, granting of relief will amount to granting principal relief.
No, which is
And
why I'm
three, the Kerala
requesting.
High Court has already negative decision.
Which is why I'm humbly requesting that these 2 points may be decided in the next hearing. Even if it takes a few more days.
Notice returnable on August.
No, my lord, it won't require him to produce 2 documents, my lord, the file
I will
and the parliamentary proceeding.
Maybe First week of August may be
No, no,
fine,
sure.
subject to convenience of any date. First week of August minutes,
29th, 30th July.
20th July, 30th July.
No, would your lordship have it on
10 August,
1st August, my lord, 1st August? Oh,
1st August.
no, I'm sorry.
1st August it can be, yes. 1st August.
Or
2nd August.
2nd August.
Second August.
I take notice for response 1 and 2 minutes.
Second,
Other,
kindly listen.
Yes, sir.
About paragraph 11 will operate.
the judgment. Madam.
Will permit them to de-stuff the.
Madam, so that is concerned because they have to pay the duty minutes. The evaluation will be done according to the notification. That is the dispute issue they are raising.
No, duty is
Firstly-
only when I clear it for import, my lord. Minus 313 rupees, no?
Returnable date. Learned, what is your good name?
Kumar MN,
So and so who appears for Union of India.
Union of India, response
Upon
1 and
service of the copy of petition in, copy of appeal in advance, shall file the
necessary.
reply come statement of objections, if any. Full stop. At this stage, learned senior counsel for the appellant invites attention of the court to the observations in paragraph 11 of the order impugned or of the order of learned single judge impugned in the appeal, which reads as under what the paragraph. Since the paper is a perishable commodity and retaining the same in the cargo would entail huge loss for the appellant petitioner, the aforesaid equitable directions are issued. Full stop. Learned advocate for the Union of India stated that the necessary de-stuffing of the cargo shall be permitted by the authorities.
No, but the duty to be payable on the
But I'm willing
That
to
should be-
following the Supreme Court order in this and several orders of several high courts. On the duty, I am willing to pay on the price declared by me. The differential duty, the Supreme Court has said bond will be given, I'll give a bond. I have no difficulty.
On that point, I have no instructions. Kindly, they have been in the court for last 2 years, madam. Just 4 weeks, next second week can be resolved all issues. Because it will come in a way of revenue.
4 weeks, there will be no paper except.
No, madam. Already they are there for 2 years in the court and they have been agitating despite suggesting them protect our interest of total duty in the form of bank guarantee and whatever is to be paid. Then it can be taken. They are not ready.
Supreme Court in Apple's case, followed in several high courts, has only said pay duty on the declared price and the differential duty give a bond. I'm willing to abide by that order. He will get a bond for the difference. Please see the Justice Nagaratna's order. Page 66. Volume 3, page 66, Miller. And this has been followed in Madras High Court.
We'll say like this. At this stage, learned senior counsel for the appellant invited attention of the court to paragraph 11 of the order of law and a single judge, then court paragraph 11. Full stop. The aforesaid directions and observations are issued by learned single judge while dismissing the writ petition. Since the paper is shown to be perishable permanent and retaining the wood, retaining the same in cargo will entail losses for the appellant petitioner. The directions of learned single judge in the above regard are equitable directions.
As far as I am concerned, only the protection of the revenue, that's it, madam.
The directions shall continue to operate in accordance with law. We are not saying anything else.
Just for a matter of interest, volume 3, page 65.
Because
and I'm not asking your lordships to do anything. Just to complete it, please see page 65. This is the order which has been followed in Madras High Court, in every other high court where this issue of MIP of any commodity arises. Please see, Miller. Interim stay of the operative portion of the impugned order, subject to the petitioner furnishing a bond for the differential duty within a period of 10 days.
But it might mean we traveling beyond scope of this control.
No, my lord, there is an interim prayer. IA was filed.
Main challenge is the validity of. These are the.
My lord, if your lordships is disposing of the main writ appeal, I am very happy.
They will operate in accordance with law. You satisfy them that this is the requirement as per the Supreme.
Very well, my lord. We'll see on the next hearing.
One indulgence, my lord. Lordship dictated that I have submitted to DS that sentence may be taken off, my lord.
Pardon?
Lordship dictated that I have submitted that I have no objection to. That is not there.
We have quoted it. We have said that it is perishable, directions are equitable in nature, and it will operate in accordance with law.
Okay.
Nothing.
Okay.
Nothing in your mouth.
Because these are revenue matters, it requires little cautious approach from as far as I am concerned.
Deeply obliged.
2nd August.
So common order in both the appeals. Two appeals.
Common order in both appeals.
Number 8. To Mahadev RK.
Appear for appellate. Appellant challenging the order for single judge. The amount petition appellant is not paid the amount 25 lakhs. Within a specific period, appellant is praised this honorable court give a 4 weeks time to deposited 25 lakhs. Already appellant paid 2 crores 45 lakhs in e-action amount.
Let us see the facts. What are facts?
Page number 29, my lordship.
Appeal. Yes.
29 page number, the honorable single judge
Yes.
observed that 25 lakhs not deposited in time. Hence, a writ petition is dismissed. Petition is
What was that application 31-123?
31?
123.
Earlier writ petition is filed, same will be dismissed. Subsequent to fresh cause of us arose.
Subject matter of the writ petition was application dated 31/1/23. What was that?
Already 2 crores 45 lakhs paid by the appellant to the respondent bank. Only 25 lakhs amount will be paid.
My lord, at page.
This application was for after the rejection.
Only dues amount e-auction sale was pending 2,66,000, out of which 2,49,000 already paid by the appellant to the respondent bank. Only 25 lakhs, press this honorable court, we have 4 weeks time to deposit 25 lakhs. This honorable court is ample power. Entire fact is residential house, my lordship. It's a residential house, aged parents are living together. After writ appeal dismiss, writ petition dismiss, subsequent to fresh cause of action, file the writ petition. Subsequently, appellant paid 2,45,000 before a respondent bank. Only due 25 lakhs e-action amount is pending, my lordship. Yes, ready to pay within 4 weeks. It's a residential aged parents. Bank is supported to the e-actioner, e-ax purchaser. Bank is collateral to the bank is a purchaser. Property is more than 8 crores, only sold for 2,59,000. Respondent bank collateral to the e-auction purchaser. This honorable court direct the petitioner e-auction deposited amount deposited with the bank. My lord, 25 lakhs is balance, my lordship. Period of 4 weeks time. Deposit is a residential house. Aged parent is there. 25 lakhs within 4 weeks paid the amount of 25 lakhs, my lords. Already 2,47,000 deposited the respondent after filing this writ petition. 2520/23 of the direction of this honorable single judge court deposited 2,45 crores. In the only balance 25 lakhs will be paid, my lords. Paid within 4 weeks without fail, otherwise dismiss the writ appeal, my lords. It's a residential house, my lords.
Lords, appearing for the respondent, my lord, may I submit?
It was a business loan. It was a business loan, 3 crores.
3 crores is the purchase of housing loan.
Housing.
It's already paid 2,45 lakhs. In 25 lakhs balance as per the e-action sale amount. Already 2,45,000 paid to respondent bank. In only 25 lakh is paid. Within 4 weeks paid. Reason we said.
Yes, my lord. My
So
lord,
what are the amount? What is the amount due?
my lord, amount is as per the sale notice about 5 crores, my lord. In fact, the sale has already taken place. Lords, this is a second round of litigation.
Yes.
5 crores according to dues from 5 crores. But sale is concerned 2,66,000. The honorable single judge stating that first deposited 2,69,000. Out of which, my lordship, is e-auction price sold 2,06,000 already paid to.
What basis you are saying 5?
2,69,000.
Notice, my lord. My lord, may I kindly see page. See,
2,60,000.
it's mentioned in the sale notice, my lord, at page.
Sorry, wrongly submitted.
Page 49, my lord, annexure D of the writ appeal, my lord. It's clearly mentioned the secured debt for the recovery of which immovable secured asset is to be sold.
Page.
As on 39/2022, my lords, it's 5 crores. Lords, also, my lords, this is a second round of litigation. If your lordship permits, I'd pass on the earlier order of this bench.
Where is page 49?
49, my lord, at annexure D, I presume. That's the copies given to me. At point number 7, my lord, that's a sale notice. And this is a sale notice issued in 2022 November, pursuant to which sale has already been conducted and confirmed. And R2 is
What amount you have deposited so far?
So far 2,45,000, my lordship, please page number 62.
deposited.
Sorry,
2 lakh,
please,
yes.
is the my case. Please page number 63, my lordship. Please see the honorable.
Not see unless we get the answer of our query.
Yes, my lordship.
And the query we are putting to the Council of Bank.
Already paid.
Please don't argue till the query is replied.
Yes, yes, my lord.
What amount they have paid?
They have paid during the pendency of the petition 2 crores, my lord, 2
Collect
crores.
2 crores.
2 crores. 2 crores, 25 lakhs they have paid.
Out of 5 crore and 10.
Yes, my lord, 5 crores, yes, my lord. And
So. Yes.
Yes, my lord. Page number 63, my lord.
Yes.
Page number 60 stating that It states that submitted pursuance of the e-action notice issued got published in respondent of Indian Express, English Daily, Samyukta Karnataka. Conducted the respondent back 18/11/22 through online bid in respect of the secured property, so and so. Is have deposited to 2,63,009, 2,63,000 sold the property. Only 25, the purchaser only 25% bid amount will be paid. Subsequently, after order of a single judge, petitioner paid 2 crore 45 lakhs, page number 63. Page number 63, para 3. Only e-bidder action, only 25 lakhs balance, the Honorable single judge stating that only 25 lakhs is due, is paid, in time is not paid.
Property sold.
Yes, my lord, R2 is the auction purchaser. Its sale has been confirmed in his favor, my lord. They've obtained a stay and proceeded to proceed. This is the second round of litigation, my lord. If my lords will permit-
That we are aware.
Sale is not confirmed.
Before
25% of the EMI amount is paid.
That we are aware.
It's a residential house, my lordship. It's a residential house. All are aged parents are living together. E-action only 2 crore 60.
You are lethargic, negligent, indolent, and too late in a day. When the sale has taken place and the sale is.
It's not confirmed, my lordship. Only sale is not confirmed. Only 25% of the bid amount is paid by the bank. All the amount paid by the appellant 2 crore 45 lakhs before the respondent. Only bid amount is 25 lakhs paid by the appellant. The Honorable Court is observed in the order. And please see the order. Honorable single judge observed in para 29th order. Even today, the matter was passed over during the
What is the next submission?
25 lakhs put back some within 4 weeks will be paid. Within 4 weeks only put some 25 lakhs.
How much?
25 lakhs as per the order of single judge. 25 lakhs will be paid within 4 weeks according to the bid amount. Any condition may be imposed. It is a residential house, my lordship, already. Any condition may be imposed, will be available. Why? Any condition may be imposed that amount will be deposited within the time fixed by the Honorable Court. Is ample power, is a residential house. Already paid 2 lakh.
So out of 5, 2 is paid.
2 is paid, my lord. But
2,45,000. 2 lakh 45 crores. 2 crores 45 lakhs will be paid by the bank with acknowledged by this court.
2 crores 45.
12 lakhs already paid the bank.
So remaining is almost half.
yes, my lord. Yes.
According to the Honorable single judge says,
Say 2 crores.
take it, sir.
Was it 2 crores then?
Sorry, 1 crore for a period of 8 weeks. 1 crore is 1 crore deposited 8 weeks.
But-
You are concerned with the money.
Humanity ground will be.
No, I
Humanity
understand,
ground.
my lord, but then this is
No, my lord,
nothing
this
but
was-
abuse of process of court, my lord, because.
No,
because
my
for
lord,
2
one,
weeks
my
you have
problem
agreed
is,
to Stay paying this.
no, action was conducted on 23/11/2022, my lord.
So what is the
And-
price fetched in the auction?
2 crore 64 lakhs, my lord. 64 lakhs 60,000.
69,000.
Already deposited 2
Next day, he obtained interim order, my lord, in the writ petition on 24/11/2022. Action was conducted on 23/11/2022. I am suffering from 24/11/2022 till 10/6/2024 in 3 writ petitions. He
Was it-
unchallenged, earlier 2 writ petition dismissed on 9/1/2023.
We are aware of.
Unchallenged, my lord.
Lord,
So
even
now-
appeal was filed, my lord.
You
That also
own,
was dis-
my lords, one submission. You want today only.
I borrowed the amount and
25% of
paid
the
the-
amount only paid. Only the auction purchaser paid the bank only 25% of the EMI amount, not paid the entire amount.
Lord, he can challenge it before DRT, my lord. In fact, this is the case
Section
where.
17 provides for all this.
Remedy is there. They can challenge the sale, notice sale certificate.
The Honorable single judge is not observed, 25 lakhs, other 2 are already observed, only 25 lakhs. Auction purchase amount is value.
The
8 crore, 1 crore will be deposited within 8 weeks, my lord. It's a residential house.
spectrum of auction and the sale confirmation is.
It's not confirmed, my lord.
You filed some reply, so showing that the sale is taken place and.
Yes, my lord, I had filed a memo of dismissal which has not been filed, but sale has been confirmed in favor of the auction purchaser. my lord.
Intimated to the writ petition.
Confirm.
And
Sale is
writ
not
petition-
confirmed. Sale is not confirmed.
No,
Sale is
has
not
been-
confirmed.
Sale was
Cash to-
confirmed
Only
the next day.
25% of the amount will be paid.
I will.
Sale confirmation is
No,
not
this
there.
writ
ma'am.
petition essentially has been filed for consideration of that representation. That we've already considered, my lord. That I'm filing here, my lord. That in fact, even before the single judge I had filed. Writ petition is not to challenge the sale notice at all. Writ petition is to consider the representation which we've already considered.
13/1/23.
Yes, my lord, we have,
Not
in fact,
considered.
we have
Subsequent-
considered that on 1/2/2023.
How many times you got the opportunity? More than 5 times earlier.
Yes.
Yes.
My lords, earlier challenge the order, so dismiss amount is not paid. Suppose one-time settlement, file an application. One-time application pending in the honorable court direct appellant to deposit it to the e-action person sale amount. Hence, the amount is paid in the one-time settlement amount, 2 crore 45 lakhs deposited. Only balance 25,000. According to the e-actions, according to the balance of the bank, 5 crores, according to the notice. But e-actions sell the property, sell the scheduled property, 2,69,000. Out of his 2,45 crores deposited. According to the London single judge observed, 25 lakhs is not paid in time, hence the writ petition is dismissed, my lords. Ready to pay, any condition may be imposed, 25 lakhs. As per the e-action sale purchase, 5 crores is there. Otherwise, 50% already paid that amount, my lords. E-action is not, sale confirmation is not confirmed, my lords.
In these facts, we are not inclined. If you want to go to bank, go again. We'll, by withdrawing the petition.
Yes.
We are not going to grant any order, nor we are asking you to deposit any amount. So that will encouraging the dishonest litigant. You are really dishonest. You are for 5 times you are given opportunity. You did not turn up.
As per the directions, honorable court, 2 crore 45 lakhs already deposited.
You are
After
not-
filing this honorable court, writ petition is
You are-
filed.
You are not ready to clear the dues. You are
Ready to pay the 1 crore, my love, 8 weeks. Ready to pay 1 crore, 8.
Go before the bank. We are
In
not.
tribunal, meantime, stay the operation of the judgment.
Chronic default. Huh?
Yes, my lord.
Division
Yes.
bench says you are
Yes,
chronic.
bench, yes, my lord, chronic default.
What do you want? An order or withdrawal?
Direct, appellate or direct to stay the operation of judgment or go to the tribunal. Alligan tribunal stay ಮಾಡಿದ್ರೆ whether sale is confirmed. Otherwise, very lapse already took, the single judge is not observed 2 crore 45 lakhs already paid after filing the writ petition.
You want to go to the tribunal?
Otherwise, the stay may be granted.
Withdraw and go. We don't. find.
Without alligan operate of single judge, my lord. Otherwise, operate the stay may be. Stay.
That was the right remedy from the beginning.
Yes.
My lord, one submission.
Time and again said.
My lord, one submission is already is a residential house, already appellant suffering, aged parents is there. The honorable court is ample power, stay the operation of single judge court order, ready to deposited 1 crore within 8 weeks. 8 weeks, 1 crore deposited 8 weeks, my lord. Otherwise, dismiss the appeal. 8 weeks is ample power. This court is ample power to stay the operation of single judge order.
What do you want? Choice is yours. Either you go before tribunal, either you seek order of this court of dismissal of the petition with cost or without cost, we do not know. And or you withdraw the petition and go to the bank. Or you simply withdraw the petition. We do not.
Withdraw direct tribunal to stay the operation of judgment. Stay the operation of judgment for a period of 4 weeks. To stay the operation of single judge order for a period of 4 weeks. In meantime, approach the DRT.
We are not going to interject in this subject, given the facts and the antecedents of your conduct.
It is true, my lordship, very financial difficulties. Already paid 2 crore 45 lakhs, my lordship. 2 crore 45 lakhs deposited.
Go before the tribunal and.
In meantime, stay the operation of judgment for a period of 4 weeks. All the matter urged before the tribunal. Period of 4 weeks, stay the operation of judgment for a period of 4 weeks. My lordship.
Which judgment?
There is no judgment.
DRT,
It's been
4 weeks may
dismissed.
stayed. Interim order may
There is no judgment, my lord. It's been dismissed. There is no judgment. Let them approach DRT.
There is nothing to be stated.
Allah, stay ಮಾಡಿದವರು. The operation sale is confirmation. The residential house, my lordship. This court is ample power. Stay the operation for a period of approach the DRT. Otherwise, entire amount collapse. Already.
Now, time starts now to exercise the choice.
After the discussion part of the court, my lordship, give opportunity for a period of 4 weeks. 4 weeks and.
We are not inclined. Sorry, Mr. Counsel. Come with the better matter. This is no case is made of. What do you want? You are withdrawing and going to tribunal, you go. We'll permit you to go.
In meantime, 4 weeks stay the operation, otherwise sale confirmation. This court is ample power, my lordship.
There is nothing to be stayed. There is nothing to be stayed. Had the auction been announced and not taken place, we would have said.
Not
that no.
confirmation of the sale, my lord. That point will be not confirmation of the sale, my lordship. Not confirmation till today, only 25% amount will be paid, not confirm the sale. Approach the DRT, not confirmation of the sale.
Confirm, my lord.
We are not granting an indulgence. It is confirmed?
Not confirm, my lordship, sorry. No, sorry, my lordship.
Sale has been confirmed in favor of auction purchaser, my lord. That is
Not confirmations.
itself.
Only, yeah, my lord, one submission. So only auction purchaser,
Not confirmed, then that is your advantage. Go and plead before. judge.
not to confirm the sale. If, not to confirm the sale for a period of 4 weeks. Request by the other residents, otherwise only residential house, my lordship.
You will go before which? Appellate tribunal, not tribunal.
No, Debt recovery tribunal, my lord. DRT, here, Bangalore. Yes,
Not
my lord.
appellate.
Yes,
Go
yes.
DRT in meantime 4 weeks time, my lordship.
While-
Approach. This court is ample power, my lordship. This court is ample power. The residential house in 4 weeks time, in meantime approach, not to sale confirmation of the subject.
The appellate heard learned advocate Mr. So-and-so, so-and-so, what is your good name?
Mahadev RK.
And learned advocate please,
Divya Purandar.
Divya,
Divya Purandar.
so-and-so for the bank and learned advocate Mr.
R2 and K Murthy, my lord.
For responder 2. Having taken the finance for purchase of residential property to the tune of 3 crores on account of non-payment of the loan, on the account of the appellant hearing with the bank was declared as non-performing asset, and the measures were initiated by the bank to recover the amount under the SURFACE Full Name Act. Full stop. In this short background, the petitioner with this short background, the case is checkered with history of litigation, where the writ petition was filed by the petitioner earlier, seeking prayer to quash the notices issued under the SURFACE Act. Full stop. The order dated 9th January 2023, passed in the earlier writ petition number 23737. We are passing order. We are passing order. At the end, we will not permit you to go.
Only one submission.
Right and now. You want to withdraw or you are inviting order?
Withdraw and
We
apply
don't
the
have
DR
time.
My lord, one withdraw and apply the DRT, my lordship. 4 weeks sale is not confirmed.
You want to go to tribunal, you straightway go.
Yes,
That is better for you.
yes, my lordship.
Learned counsel for the petitioner states that the petitioner, the appellant petitioner states and submits that the appellant would avail the remedy before the debt recovery tribunal in relation to the subject matter and the grievance raised in this petition.
Yes.
Full stop. Learned advocate Ms. Divya so-and-so for the bank has no objection if the petitioner takes such recourse.
Yes.
In accordance with law. Full stop. Without expressing any opinion on the merits of the case or in respect of the proceedings which may be taken out with the tribunal by the appellant, the petition is dismissed,
Yes.
reserving liberty
Yes,
to
my
the
lord.
petitioner to
Yes.
approach the tribunal.
Much obliged.
Number 9.
G category sites matter, where the committee had to be reconstituted in light of
No, last time we had passed the order on 20th/6/24 requiring the registrar to take consent of the probable members of the committee. Instead of pursuing those observations, we feel that the committee may function with the 2 members who are presently existing.
We're in your lordship's hand.
So we'll modify the order. We'll pass that order. Very good. You will pass, where is the government here? We'll pass consequential order.
Please, Madam, and the government will have to follow whatever your lordship.
So making the two-member committee.
Absolutely.
We'll pass the.
Great.
Yes, all other conditions will remain.
Yes, Madam, absolutely the same.
Farming for the.
Grateful.
Grateful here.
Ten and 11 are urgent. Number 12. Stay Ramana.
Your Lordship, in this case, directed the government advocate to consider the Supreme Court order, interim order on the last occasion.
Appearing for the government. My lord, I have written to government. I haven't received the instruction, my lord. If my lord could grant me some time, my lord.
We'll grant time, 23rd July,
Like,
Lordship,
29th July.
even from 17/3/2023, they are taking time.
We are awaiting instructions. He will take.
right.
Number 13. The Shrikant Patil case.
Yes, my lord. My lord, in appeal number 13.1, my lord. The respondent number 8 had died, my lord, and I have filed a LR application, my lord, to bring the legal heirs of the 6th respondent, my lord, to come on record, my lord. Those applications may be allowed, my lord, and
Applications, I think, although writ appeal, my lord, this LR application is there. Requires to allow them.
and in fact, on the main matter, my lord, on the last occasion, your lordship had expressed that, my lord, the matter itself would be heard on main, my lord.
So notice in IA number 2 of 24, 3 of 24 and 4 of 20.
My lord, in the connected matter, my
Which are
lord,
for bringing the heirs and legal representatives of the deceased party on record. Full stop. The notice shall be returnable on 7th August.
my lord, since my lord, Mr. Satish appears, my lord, in respect of other
And in 13 IA
respondents, my lord.
2 of 24, notice.
Notice may go to the parties. Advocate on record has no instructions with respect to
We are
that.
issuing notice.
Notice may go to the parties, my lord.
Yes.
Please.
In 30th notice in IA for delay. One of 20, also 13.2, wherever IA for delay is there, notice in all group.
It's number 14. Vaishali Agde.
Therefore, appellant in 14.1.
Yeah, 18%. My lord. Nine. 18th. 18th.
May I request my lords to take the submissions which was handed out last time, which has the copies of the interim order and the statute, my lord. Would be much easier. We gave a submission, my lords, on the last date of hearing. Why don't you help the court officer to? It's at page 12, the last page my lords, of this is the order made by your lordships on 24/4/2024. Last page. Is the copy of the order.
Which is the section? Which is the section under with the
That is section 31. my lords.
31?
31. That my lord will find at page 8, my lords, of the submission. Term of the office of the members of Senate, Syndicate and Academic Council. My lord has that. my lord. Save as otherwise provided in this act, the Senate, Syndicate and Academic Council shall be reconstituted at or about the same time every 3 years.
Ready.
Members of the authority shall, except in the case of ex officio members, hold office as members thereof up to the date of next reconstitution. Now, this reconstitution takes place, my lords, every 3 years in terms of section 31. Kindly take my submission, my lords, I have set out at page 2. When, my lords, in the past, the constitution has taken place and
I
reconstituted.
may make a submission, my lord. My lord, senior is on his legs in apartheid matter, my lord. So I was waiting for him. If my lords may kindly pass over.
What do you want?
My lord.
Monday. Now,
I need to show only this, that it
When
has,
you are for the petitioners, respondents.
I'm for the respondent university.
So when they were nominated, date?
Lords, they were nominated on 16/6/2021. The last of the constitution, 9th constitution, was on 16/6/2021 for a period of 3 years, which completed on 15/6/2024.
No, 16/6/21 you said.
No.
The period of 3 years, my lord, comes to an end on 15/6/2024.
Correct.
Now, my lords, the constitution is different from the nomination.
Let submission with respect to that extent is concerned.
Now, let's see, nomination may vary at different point of time. It may be delayedly made or made in different point of time. What is important is the statutory operation of section 30.
New body is constituted.
We have not constituted, because of the interim order. All that we are seeking is, your lords may say the statutory provisions operate. I don't want anything further than that, my lords.
We'll permit the process to reconstitute. the
Yes,
body.
all that, we are only saying that irrespective of deciding whether the term has come or not, because 31 is very clear that once it is reconstituted, the term comes to an end.
But it's on number submission, right? So with respect to submission.
You can't have the cake not cut and eat too.
My lords, there was no reconstitution even in the year 2021, my lord. For them to say that
That's for a moment, my lords, with respect to submission that the reconstitution and nominations are entirely different. If I kindly take your lordship to section 24, the syndicate shall consist of following members. It says, my lords, it shall consist of following members. And we can't take a nomination and a constitution as a two different.
constitution
We permit the process of reconstitution to start. That's. May I just submit? Then Monday. Take your time, no issue.
But I want to point out from their own documents that there has never been a reconstitution in 21. After 15, there has been no they have not placed any material. I can show that.
That is not the question. Question
The
is of
statute says so.
your right to continue and your right to withhold the process of reconstitution. That is the question. Can you withhold indirectly the process of reconstituting the body?
No, I can.
That's the only.
There are two things.
You will.
Monday.
Serial number 31 is also item
Number 23. Number 23.
Oh. You request, you want me to ask for a.
20?
26, Pollution Control Board Chairman's Act. Where the
31. You
government
think
expiry
I'm
member-
there to ask for
When?
the adjournment?
Now, 14th
Adjournment.
one way or the other,
Yes.
they have, they're
You are.
Filed our objections, matter.
continuously, they've tried to remove him. And now this is the final salvo, where they have removed him. But could it be taken on?
Any other matter is kept on it. Nine. Nine.
Maybe a little. Oh, ninth. Very well. Tuesday.
My lords, one more request. Serial number 31 is identical to the one which your lordship. That could be tagged on. It's the same argument, but it can be tagged on. 31.
31.
With the
No.
pleasure,
Same petition.
serial number, with serial number 14. Madam. That's also another syndicate member.
27.
Up at 2:30. 2:30.
But ninth at 2:30. This one.
You mention on that.
That day.
Serial number 27, Malad.
27 onwards.
We appear for the appellants in serial 27, my lord.
No wage matter, Malad.
That retics. Group.
Group matters,
Group
please.
matters.
Group matters. Serial number 27.
But I also appear in 27, some of the appellant.
Oh, Mr. Naganand is appearing. 11th August, my lord.
Please.
Interim order may continue. Interim order may be continued.
Serial number 20, my lord.
Interim orders.
For recall, my lord. It was dismissed for non-prosecution. If I may take it, if it's taken on Monday, 34, my lord.
9.2. The yesterday, day before yesterday, my lord, lordships heard that open at section 11 matter.
Which is that? Which are the serial number?
Appeared, sir. That section 11 matter, lordships had not tagged the other matters also today.
Serial 21, my lord, that is.
Now,
I also.
lordships may have it short. Our compensation is not paid, Lord. That's why I'm saying. Our any earliest date, Lord, lordship's convenience, because there is no compensation paid. I am ready to say, Lord, 2 prayers have become infructuous. Short argument.
29, my lord.
Serial number
Short date.
24, my lord.
Service has to be completed, my lord, in all the connected cases.
No, the compensation is, my lord, the core issue. The service.
Notice issues ಆಗಿಲ್ಲ.